Well, howdy there, folks. James, politicalfriar.com, coming to you again. I got the law hat on because we got a long awaited decision from the D.C. Appeals Court this morning. This was a case, actually, that the channel hasn't covered. It's another Trump case, of course, but we haven't really gone through it. It's one that was brought by various Capitol Police officers and Congress members against Donald Trump for his behavior up to January 6th and then on January 6th and inciting the riot that occurred at the Capitol. Some people will call it an insurrection. Some people will call it a protest. Some people will call it a demonstration. Some people will call it a riot. That's a matter of fact for juries to figure out. This case calls it a riot. So I'm going with riot in this video. You've heard me call it other things in other videos, but the context is key here. And so the riot that allegedly caused these Capitol Police officers to be attacked, harmed by the crowd. And the allegation basically goes that Trump's actions after the election in stirring up the conspiracy that the election was stolen, using inciting language over the course of months, and then capped by his speech at the ellipse, foreseeably caused that harm. It is a tort. I mean, it's going to be something that if you can prove the facts, you could get relief unless there's some sort of affirmative defense. And it is an affirmative defense that this ruling revolves around. It's the affirmative defense of presidential immunity. Now, in the 1970s, the Supreme Court recognized, actually, I guess the case finally got brought down in 1982, but in a case that involved former President Nixon, the Supreme Court recognized that a president cannot be held civilly liable for acts that he does in his official capacity, even if those acts are blatantly illegal. For example, ordering an assassination. Well, that's illegal. The United States has laws that says that we don't assassinate people, except, of course, we do. And the president cannot be held civilly liable by the victim of that assassination for his ordering of that assassination. That is the idea behind presidential immunity, is that when the president is acting within his official capacity as the chief executive of the country, then no civil liability can be attached to him, regardless of how bad his actions are. And Trump argues that this is indeed what he was doing. He was acting in his official capacity as president when he was disputing the election, and the court didn't buy it. The court didn't buy it for pretty obvious reasons, because the inquiry comes down to, are you acting in a private capacity as a candidate disputing the election, or are you acting as in your official capacity as a president disputing the election? And the court has to come down on the idea that no, Trump, when he was giving his speeches and making his tweets, was a candidate for president, and thus acting in a private capacity, not the president acting in his official capacity. So no immunity attaches. There's a couple of complications to this, though. The only argument that the court affirmatively rejected was the test that President Trump's lawyers put forward for deciding when a president was acting in their official versus their private capacity. And the test they proposed was, whenever a president is speaking on matters of public concern, it's official. And that cannot possibly be right, because every campaign stop, every convention acceptance speech, every bit of a presidential campaign is going to be on matters of public concern. And so you would have a candidate running for office who was the incumbent president being able to say literally anything he wants as long as it's on public concern without any of the natural repercussions, and the person running against him, who isn't the incumbent, not having that same speech right. That can't be. So that is the one legal concept that this court affirmatively rejected. It also affirmatively rejected, I suppose, the take care clause argument. The take care clause is in the Article 2 of the Constitution. It says that the president is charged to take care of the country and enforce the laws. The thing is, you're always acting in your official capacity when you're taking care of the country and enforcing the laws. And so this argument collapses into itself. The same inquiry is applied here as above, which is whether he was acting in his official capacity. If he's acting in his official capacity, then he's taking care of the country and enforcing its laws. If he's not, then he's not. And so the same basic inquiry is applied, which is, was Donald Trump, during his efforts to overturn the election, acting as the president or acting as candidate Trump? And the court says candidate Trump, but the court says candidate Trump, not exclusive of this argument coming back around. This is something that we have to address, and that the procedural posture of this case is before any discovery, before any facts, before any trial, before anything that might change the pleadings. So this ruling was based on a presumption that everything the plaintiff said is true. Well, that is a big presumption, and one that Trump will have the opportunity to refute. And if, in refuting the facts of the plaintiff's complaint, the alleged facts of the plaintiff's complaint, the legal application of those facts changed, then this could change too. So, for example, if Donald Trump brings in evidence that shows that his actions were indeed official acts and not campaign acts, then the court could revisit this decision and decide that he actually is immune. Now, the court did a really good job of pre-butting all of that by demonstrating how the presidential campaign paid for most everything, how Donald Trump acknowledged that he was a candidate acting in his personal capacity when he intervened in the 60 plus lawsuits seeking to overturn the election. I mean, it's not going to be a great argument, but it's one that the court left open. And in leaving it open, you have to understand this as kind of a nothing. Yes, Donald Trump lost the narrow legal battle on the test of when a president is speaking in his official versus private capacity, but that was a long shot. And yes, Donald Trump didn't get this case thrown out. It's going to keep grinding through the courts, but that's going to take time. This case was argued almost a year ago, and we didn't get a decision for a year. Well, 360 and 55 days we didn't get a decision. So don't expect this to have a huge impact on, well, really anything. If your liberal friends come up to you and say, "Yeah, did you see that Donnie got hit again?" That's true, but doesn't mean much. Or if your conservatives friends say, "Yeah, but that's just a nothing burger. There's nothing to it." Well, they're kind of more right. I'm sorry to report to you. This issue will swing back again after some facts have been introduced in the case, and we'll hear about it on summary judgment. Now, based on what we know, do I think that there's much of a chance of this decision being reversed after there are facts presented? No, but that's why we go through discovery. That's why we actually have those facts brought into the record so that we can make a complete decision. This is worth talking about, but that's about it. I don't think it's going to have much of an effect. Anyway, that's just my thoughts. Tell me how wrong I am in the comments down below. Leave a like on this video. Tell a friend, and hit that subscribe button. Subscribe button really helps, so you don't miss the next one. When the next decision comes out, because I'll read these for you, so you don't have to. All right. Thanks.